Senator Leding, you're recognized to present Senate Bill 500.
Just to briefly explain the amendment, this is just an amendment that DHS asked for that just makes one minor change and clarifies that this would only apply during criminal investigations. So I would move adoption of the amendment.
Okay. You got a second? Any discussion? Hearing none, all for the motion signify by saying aye. Aye. All opposed? Motion carried. Your bill is amended. If you'd like to present your bill as amended, Senator Leding.
Yes, thank you, Mr. Chair and Committee. I'll be very brief. Simply, Senate Bill 500 is just going to make sure that anybody who is 15 years of age or younger is entitled to speak with an attorney, whether in person, by phone, or over video, before waiving their rights and proceeding with an investigation. And I've got Mr. Dold here to further explain the bill.
Thank you so much, Mr. Chairman. James Dold for the record. I'm the founder of Human Rights for Kids, which is a child rights advocacy organization based in Washington, D.C. We work to advance, promote, and protect the human rights of children around the United States. And we're very grateful to Senator Leding for introducing SB 500. This bill is really about protecting and ensuring the protection of children's constitutional rights. Over the last several years, in the last couple of decades, juvenile brain and behavioral development science has significantly advanced in this country, so that our understanding of the way that children think about issues isn't fully reflected in the way that their brains process information. So specifically, children's brains aren't fully developed, and so they actually rely on the more primitive part of their brain called the amygdala to process information. This is what makes children more impetuous, more susceptible to peer pressure, and also irrational decision-making. It's also one of the reasons why in society we protect children from making certain decisions, because we recognize that they don't have the sophistication, the same sophistication as adults do. So for example, we don't allow children to vote. They can't serve in the military, enter into contracts, or engage in other adult-related activities because we recognize that they lack specific decision-making capacity. And so what we're trying to do here in SB 500 is to make sure that whenever we have children who come into contact with the criminal justice system, that before they waive their constitutional rights, which is a very significant right, particularly the Miranda rights, that they have the opportunity to consult with counsel first. And I think one of the things that's notable on this issue in particular is the fact when we look at the research that has been done by the University of Michigan, which runs the National Registry of Exonerations, the rates of false confessions of juvenile offenders are particularly stark of all of the individuals who've been exonerated over the last 25 years. So of those individuals who've been exonerated over the last 25 years, children in those instances have falsely confessed to crimes that they did not commit about 40% of the time. Now, those are children under the age of 18, and so when we look at children 15 and younger, that is particularly stark. So nearly 60% of children who are age 14 or 15 who were later exonerated of crimes that they did not commit had actually falsely confessed to the crimes that they did not commit. And then when we look at children under the age of 14, those numbers are even higher, at 87%. So nearly almost 100% of all children under the age of 14 who were later exonerated falsely confessed to crimes that they did not commit. And this is in part due to just how children lack an understanding of what it means to waive their Miranda rights, what it means to be in a custodial interrogation, and what it means when they make certain statements when they're being interviewed. And so this bill is really intended to protect and safeguard children's constitutional rights, just so that we make sure that they fully understand their constitutional rights, their Miranda rights, and that they have an opportunity to consult with counsel before they waive those important rights. There are some exceptions within this bill that I just want to highlight real quickly. So in Section 2, which is really the meat of the bill, this requires that before a minor can waive their Miranda rights, they have to consult with an attorney before they can waive it. But that does not mean that any statements that are made are necessarily inadmissible. This requires a judge simply to consider the failure to comply with this section in the statute as one consideration on whether or not those statements should be admissible. And then we've created an exception in this bill as well for public safety circumstances. So, for instance, if a law enforcement officer who is questioning a minor reasonably believes that the information he or she seeks is necessary to protect life or property from imminent threat or harm, this section would not apply. And so we've tried to carve out that public safety exception to ensure that law enforcement officers have the ability still to interrogate children under the age of 16, and that those statements would still be admissible in those very rare circumstances. But outside of those circumstances where it's necessary to protect the public from harm, we want to make sure that children have their constitutional rights protected. And so with that, I'm happy to close and answer any questions.
Senator Flowers.
So with this bill, if it becomes law, then children under 16 accused of criminal offenses would have a right to an attorney before waiving his or her rights.
That is correct.
Okay. So if they're in custody, the child, I believe there's a limit on the amount of time they can remain in custody before being brought to a court. Is that right?
It is. I'm not quite sure what that time limit is, though.
I mean, they can only hold them for so long. So if at the time of arrest and while they're in custody, they're not appearing before a judge and no lawyer has been appointed by a judge to represent that child, and the family is too poor to pay for an attorney, then what are the issues there? Are we releasing somebody because of lack of evidence that might come from interrogation? And how does this play out?
Thank you, Senator Flowers. James Dole for the record. So the law enforcement officers would have probable cause for an arrest. It's just at that point in time, once the arrest has taken place, before there can be a custodial interrogation, the child must consult with an attorney. And so the reason that we've specified in the legislation that consultation could be over the phone or telephone or video conference is to make it easier on the state to make sure that it's easy to comply with this section. So all they have to do is have a phone call with an attorney just to say, this is, what's going on, this is where I'm at, and the attorney can provide advice on whether or not that child should waive their Miranda rights or not, or what they should do going forward in those circumstances.
Any other questions from the committee? We have Lori Campuris and Kyle Hunter. I think y'all will be together. Am I incorrect? Signed up to testify against. Please identify yourselves for the record.
Mr. Chairman, members of the committee, I'm Lori Campuris, the Deputy Prosecutor Coordinator. I have with me Mr. Kyle Hunter, who's President of the Arkansas Prosecuting Attorneys Association.
Please proceed.
Thank you. First of all, I'd just like to say that prosecuting attorneys also are concerned about the rights of juvenile offenders, and our opposition to this bill has to do with issues other than the fact that we are not concerned about the rights of those offenders. First of all, we feel like under our current system, the juvenile system, we have adequate protections in place to protect minors, even those that are charged as adults. The way our juvenile justice system is designed, there's only a few crimes that juveniles age 14 and 15 can be charged directly in circuit court as an adult by a prosecutor, and those are some of the most serious crimes out there. You know, the murder offenses, kidnapping, rape, things like that. There's actually 7 of those. The other crimes that a 14 and 15-year-old could be charged as an adult for would have to be actually filed in juvenile court, which means they're going to have special rights to counsel, the right to have their parent present, all of that before they're actually giving statements to police. And those crimes, there's a longer list of those crimes, but as I said, the way our system is designed, those charges would be filed in juvenile court, and the prosecutor would have to actually file a motion to transfer to adult court or to have it transferred as an extended juvenile jurisdiction case. In the 7 crimes, the most serious crimes, even in those crimes, most of the time a court is going to be involved in determining whether a statement made by a juvenile is freely and voluntarily given, because in almost all cases where a juvenile is charged, there's a motion to transfer filed by a defense attorney, in which case the court can consider whether it should proceed in adult court or juvenile court. So based on those things, we do feel like that there are adequate protections in place to make sure that any statements made without counsel were freely and voluntarily given. One other concern that we have has to do with the fact that a lot of times we want juveniles to have the protection of juvenile court, particularly in cases involving sex offenders. And if they are routinely not waiving the right to counsel, or an attorney is present, a lot of times they may end up not even in the juvenile system. And if we can get juvenile sex offenders treatment and resources from the juvenile system at a young age, then we feel like we're protecting society, but we are also helping the juvenile not to go on to be an adult sex offender. So those are some of the concerns that we have, and I think Mr. Hunter may have some additional comments and concerns as well.
Mr. Hunter?
Thank you, Mr. Chair and committee. I did want to make clear that just as an adult, that juveniles do have the right to counsel and consult with an attorney prior to giving any type of statement. And those rights are given to them under Miranda, just like an adult has. What this bill particularly does is prohibits them from waiving that particular right. It also should be noted that in juvenile court, for a statement of a juvenile to be admissible, that their parent has to be there at the time of the interrogation, and actually that parent would be the one that would waive the right to counsel after consulting with their child. And this bill would stop that from happening. In other words, it would actually require an attorney to be there. And some of the mechanics of that, of course, no one's appointed to represent that attorney, that child at the time, and and typically the public defender's office doesn't represent a client until they're appointed to represent that client, and so this would also hamstring or put handcuffs on solving crimes by law enforcement. And there are those with the concern about a child being pressured into giving a statement. Those issues, he does have a remedy. I mean, does have a just like an adult. Those in custodial statements are presumed not to be voluntary until in a hearing, and they have to be proven by the state that statement was. That their rights were understood, and that they voluntarily waived their right to remain silent and voluntarily waived their right to counsel. And the court would have to find those things before a statement could be admissible, even against that juvenile. Also, there's been a recent study, sometime in the last couple of years, I think it was Act 189, where it was ended up being codified, where people got together here in the state, juvenile court judges, prosecutors, other interested people in the juvenile system, to evaluate the juvenile system. And out of that came these risk assessments and a lot of other things to try to improve the juvenile justice system. And this was not one of those things that came out of that. So I've rambled a little bit, but I wanted to bring a few of those issues to light, and we could answer any questions.
Senator Cooper.
Thank you, Mr. Chair. Do you accept the statistics that you heard there a while ago presented by the sponsor of the bill is valid? Do you accept those?
I've not seen those statistics. I don't know if they're true or not, but one thing, that he qualified them with was in cases where they've been exonerated, that in some of those cases, in a high percentage of those cases, he says they had falsely confessed. I don't know how many cases they've actually been exonerated in, so that's what qualifies all those statistics. So I don't know that those are true or not. No, I do not accept them.
So you hadn't seen anything that coincide with that statistically?
I have not. I'm not saying that they're not, what he said is not true. I just can't verify them.
Okay. So if you were satisfied with the system now that's protecting their rights, if there was a discrepancy there, that's assuming they are correct, would you have a explanation of why they wouldn't be? I know it's leading you down a path that you probably don't agree with, but can you shed any light on what might be happening there?
Well, and I don't know how many cases that those are, to where, it could be, say there were 10 cases across the country where someone was exonerated, and in those 10 cases, 8 of them where they falsely confessed. Well, there may be a million cases where they weren't exonerated, where they'd given statements. So those statistics have got to be put in a proper perspective in order to understand them.
Okay, thank you.
Senator Flowers.
So, if a juvenile is taken into custody and a determination is made to charge immediately as an adult, that's one situation. That can happen, right? Is that right?
Yes, that could happen for certain crimes. That's right.
Okay. And the other situation is where a juvenile is taken into custody and taken to juvenile detention and charged with being a delinquent for having committed or alleged to have committed criminal offenses. Is that correct?
That's correct.
And in the instance where the juvenile is charged with a delinquency petition alleging violation of criminal code provisions, that's where the parent has to be there with the child in order to waive the interrogation or anything else, his rights.
That's correct. That statement would not be able to be used against them in juvenile court unless the parent was there during the interrogation.
And in the instance where the minor is charged as an adult, in circuit court proceedings, they have the same rights as any other adult defendant. Is that right?
That's correct.
And so I'm thinking the reason Senator Leding, and he could say if I'm right or wrong, but he's trying to at least particularly protect those that are charged with as an adult. Would you see that as being a difference? Being charged as an adult, where that minor has to make these decisions without the benefit even of a parent? Or do they have the benefit of the parent to assist in making the decision as to waiving rights?
If they're charged as an adult, then that requirement that the parent be there is not necessary. Now, the weighing factors the court would have to go through to determine whether that was a knowing and voluntary statement given by the minor would still be in effect. I can tell you that in our jurisdiction, Senator Flowers, because we never know whether we're going to charge someone as an adult or as a juvenile when they're first picked up and interrogated by police. And because of that, law enforcement there always will never interrogate a juvenile without the parent there. And for the reason is that if my office decides not to charge as an adult but as a juvenile, that statement would not be admissible in juvenile court. And so to avoid that problem, which you don't know at the point of interrogation, law enforcement in our jurisdiction, and I don't know if that's that way all the way across the state, but I know it is in many places, want to have the parent there at the time of the interrogation to protect that statement.
And I think that's the strike of protection, it seems to me. If you're talking about custodial interrogation, at least prior to charges, and it's a juvenile, I think our code now requires the parent to be present and to waive the child's rights. Now, Ms. Campiris, I don't know, or if somebody else is in here, the defense counsel for the public defender, they can speak on that too. But my understanding is when a child is taken into custody, there has to be a parent present to waive any rights.
I would agree with that, Senator Flowers, and I think, as Mr. Hunter pointed out, majority of the time when a juvenile is detained and arrested, it's going to be up to the prosecutor whether to charge as an adult or a juvenile, and so law enforcement is not going to know immediately unless the prosecutor has indicated that to them. So they have a duty to try to get the parent there before they do any custodial interrogation.
Mr. Hunter, Ms. Campiris, I had a question from what you said a while ago. How does a juvenile waive a right?
Well, when the juvenile's in custody and when his parents are called there to be there during the interrogation, they are given, the parents and the juvenile are advised of the Miranda rights, the same as an adult is. The right to remain, basically the right to remain silent and the right to counsel. And they would waive that right by saying that they understand and they go ahead and give a statement. And usually, sometimes the parents tell the child not to say anything till we get a lawyer, and sometimes the parent tells the child to go ahead and talk. But that's the process that happens.
Well, I heard that part separately. That's why I was asking. I heard you say second that the parent could waive the right, but I also thought I heard you say before that the juvenile could waive the right.
Well, they in the situation that I'm talking about with the parent and the juvenile there, that's a joint decision because unless...
But it requires the parent.
Yes.
Okay, yeah, that confused me. Okay, we have James Doles. Okay, never mind. So, Mr. Parrish, could you come to the table?
Greg Parrish, Arkansas Public Defender Commission. Yes, sir, Mr. Chair.
I'm sorry, Mr. Hunter and Ms. Campiris, could y'all stay at the table? I think we may need you. Senator Flowers, you have a specific question, or would you like Mr. Parrish just to weigh in on this bill?
Yes, I'd like for him to weigh in on this process and whether or not it's true that a child, a minor, taken into custody has to have the parent with him or her in order to waive Miranda rights?
It's my understanding of the law, Senator, and I respect what Mr. Hunter says. And it may be different in my experiences, but typically what I have seen in 30 years of practice is most of the time, parents waive the right for the juvenile. They will waive it. And they do not understand what right they're giving up for their child, which then could still result, if that child makes a statement, that child being charged in adult court and that statement being used against that child.
So I hear you, although you're not signed up to do so, speaking in favor of the bill.
I would favor it, Senator. Procedurally, I have a question, though, as to who's going to be called. Because, you know, these arrests could occur at 4 o'clock in the afternoon or 4 o'clock in the morning. And at that time, once the arrest takes place, the public defender is not appointed. And so if that juvenile wants to talk to somebody, i.e. an attorney, who would be called? And that's from a procedural standpoint. But I favor the bill that the juvenile is allowed to speak with an attorney before questioning.
Right. Senator Flowers?
Okay, so I'm trying to strike a balance here because, I mean, our law is what it is, and it requires the parent there in order for the juvenile's rights to be waived.
I'm not sure that it requires the parent to be there. I've seen it occur by phone before as well.
Well, the letter of the law, what is that?
Senator, I might have to defer because it's been 10 years since I've been in juvenile court, to be honest with you. And I'm sitting here trying to look up the specific case that we're talking about right now.
But I'm fairly certain that it's in statute that a parent has to be present. I mean, does anybody have the statute?
Well, we're looking up the statute now, but it is statutory that requires the parent to be there. I'm not aware of the situation where phone calls get made to a parent because our law enforcement have to get the parent there.
It has to
have
be
the parent in
signed.
the room, and the parent then has a chance to talk to their child and determine whether to waive the right to counsel and make a statement or to not make a statement and ask for a lawyer. And
as my understanding and in my experience, that waiver has to be signed. So I don't know about this telephone call because you can't sign something over the telephone. So that would seem to me to be reversible error right there. So, I mean...
Senator Flowers, in 927-317 Arkansas Code is the one that deals with waiver of right to counsel and detention of juveniles. And I'm trying to kind of read through there, but it starts by saying the waiver of the right to counsel at a delinquency hearing shall be accepted only upon a finding by the court from clear and convincing evidence after questioning the juvenile that the juvenile understands the full rights of the right implications of the right to counsel and that they freely, voluntarily, and intelligently waive that right. And then it says the parent, guardian, custodian, or counsel for the juvenile has agreed with the juvenile's decision to waive the right to counsel. And the agreement of the parent shall only be accepted by the court if the court finds that the parent had no adverse interest to the juvenile, again, that it was freely given, and that the person has consulted with the juvenile in regard to their waiver of the right to counsel. Trying to find the part about the writing. I don't see that right off the bat, but all waivers of the right to counsel except those made in the presence of the court shall be in writing and signed by the juvenile. when a parent cannot be located or is located and refuses to go to the place where the juvenile is being held, counsel shall be appointed for the juvenile.
So then that sounds like if at interrogation no parent can be found, then the court has to immediately appoint an attorney.
Yes, I would agree with that.
So, Senator Leding and Councilor Parrish, if you want to comment on that or respond to that.
Senator, I would like to respond because I've got some very vital assistance over my right shoulder. And it's my understanding from the Miller v. State case that this statute only applies when they're charged as a juvenile. So if they've made a statement and then they're charged as adult, it's our understanding the statute would have no implication.
And
that's
I agree
according
with that.
to Miller?
Well, I'm reading the statute right now, Judge, and excuse me, Senator, and I have not pulled up the case. I'm trying to pull the case up right now as we speak.
I agree with that applies in juvenile court. But the point that Mr. Hunter and I tried to make initially is that in a majority of the cases, there's only about 7 crimes where a prosecutor can directly file as an adult in adult court. And if law enforcement doesn't know that, they're going to treat that case as if it's going to be filed in juvenile court, in which case all those protections are going to be in place until such time as the juvenile's formally charged as an adult.
Do I have anyone else here to speak against the bill? I have Judge Stacy Zimmerman signed up to speak for the bill. She'll tell us. Judge, if you will identify yourself for the record.
Yes, I'm Judge Stacy Zimmerman. I'm a juvenile division circuit judge out of Washington and Madison counties. And I just had a few observations of this bill. It is true that when a juvenile is questioned and they're going to file as a juvenile on a delinquency case, that juvenile has the right to have their parent present, and a waiver would have to be signed by the parent and the juvenile before that juvenile could give a statement. That protection does not apply to a juvenile when the prosecuting attorney decides to file as an adult. And so if you're a parent and your child is 16 and has stolen a vehicle, that's a felony for which that child could be filed on as an adult. And in the questioning of that juvenile, if they're filing as an adult, that child has no right to have their parents present before that juvenile is going to speak to law enforcement. So that juvenile, even though he's facing higher consequences than the juvenile who's filed on as a delinquent in juvenile court, has higher consequences in the long run, his parents are not given the right to be there before he's questioned. And it may be in their jurisdiction that the juvenile's parents are always there before a waiver is signed. But oftentimes in jurisdictions, law enforcement has the child there. They're wanting to question him. They call the prosecuting attorney in the middle of the night and says, will you file on this kid as an adult? And they tell the law enforcement, yes. And so law enforcement proceeds to question that juvenile without their parent present. Now, I don't know about you, but my 16-year-old, when he was 16, if he was accused of committing a crime, especially one that he could be filed on as an adult, his mama would want to be there before he's questioned. So I, as a person, think that this would be a good bill to support, to give the same protections for a juvenile that they get in juvenile delinquency cases if they're going to be filed on as an adult. So that protection in the juvenile code about having your parent there is not a protection afforded to the other juvenile when the prosecutor decides to file. So it's prosecutorially driven about how much protection that kid has, not because of his IQ or the color of his skin or what he did, but because the prosecutors decided to file on him as an adult. And I was a prosecutor for 8 years before I became a judge, so I understand their objections, and I just wanted to put that out there, that protection does not carry over to the adult side in the interrogation at the beginning of the investigation.
Judge, do you think this is a good remedy, or is there something less that can be done that doesn't complicate the process as much?
Well, if you're thinking about it's your child and they're going to be charged as an adult, think about it from your perspective as a parent. Would you want to be involved to talk to your kid before they talk to law enforcement? I think the answer is yes. And if that means that the public defender would need to be called in the middle of the night, or maybe a rotating system, just like we do in juvenile court with our officers, when a kid's arrested, taken to JDC, we get calls in the middle of the night, and our officers say, yes, take him to detention. Yes, it's inconvenient, but we're talking about a kid who's facing criminal charges in adult division and could be facing up to 40 years in prison. To me, it's an inconvenience, but it's one that's warranted. And I think if you would also look at disproportionate minority lockup, I think that would also give you pause to say, the parent needs to be involved. Thank you, sir.
Judge, what if it specified that it was only if they were going to be charged as an adult?
Well, I think that's the whole issue here.
That is the whole issue. Central Flowers.
So, Judge, I don't know if you've had time to look at the whole bill.
I've looked at the bill, but I've not looked at the, I think you said there were some amendments?
That's all
Okay.
the amendment does right there.
Is there some language that could add the protection, and I'll ask you that too, Attorney Hunter, to give the protection for those minors that may, at the instance of arrest or soon thereafter, while in custody and before brought to the court, there's communication and understanding that they're going to be charged as an adult, to protect them, at least giving them the same protection as a juvenile charged with a delinquency, in so much as having the parent available and present, mandatory presence or of the child, of the parent to sign the waiver.
That would narrow the bill, because the bill at this point even applies to those juveniles who are going to be charged with a delinquency petition in juvenile court. Requires this attorney to be there, even though their parents are required to be there in that situation. And from the beginning, I agreed that if a statement is made by a juvenile and they're charged as an adult, then that requirement's not there to have a parent there. But in practicality, in our jurisdiction, and we have a parent there because we don't know if we're going to charge them as an adult or as a juvenile at that time. And so we want to protect the integrity of that statement. One narrower way, rather than requiring an attorney, would be to require the parent to be there.
And so that part of the code that Ms. Kempers read for us, Judge Zimmerman, if that was extended not only to delinquency proceedings, but adult criminal proceedings, would remedy.
I think that really would. And I have to say that as the Committee of Juvenile Judges, the committee itself is against this, but I think that they see that there are some really good parts, and we maybe need to sit down and visit a little more to come together on something that can help the situation. So maybe a little more time to talk about maybe some more amendments. And I've just given the Miller versus State case where it says a juvenile was adjudicated delinquent in Pulaski County for capital murder committed when the juvenile was 4 days away from his 14th birthday. The juvenile appealed. Arkansas Supreme Court held, this is one that's shy of 14, for capital murder. The officers were not required to inform juveniles of their statutory right to speak with their parent or guardian, or to have one present during questioning, and evidence supported findings that the juvenile's statement was voluntarily given and that he knowingly and intelligently waived his Miranda rights. That's a 13-year-old, wasn't told he could have his parent there, and he's facing capital murder.
And so, and I think Senator Leding, I think I would like to see the bill amended so that at least the parent is present and mandated to be present in that protection that you have now with the delinquency proceedings against a minor. And another thing I'll note, in my experience, sometimes, even though there's interrogation that has taken place, there's not always a delinquency petition filed. It might be deferred. And so, charges, and you can comment on that if you like, Judge Zimmerman, but after interrogation is not always necessarily even a petition for delinquency file. But I'd like for the Senator Leding to comment on the possibility of amending it for that protection to be given a juvenile that may be charged as an adult.
Thank you, Madam Vice Chair. We would be willing to add parent to line 26, page 2 of the bill, with the caveat that sometimes the parent is also a suspect. And so we're not necessarily comfortable with the idea that the parent would be able to help the child waive their rights in that situation. But if that's what the committee would prefer, we would be willing to make that amendment.
Well, if the parent is a suspect and in custody or something, then the state gets involved, DHS, I would think. And so the child is going to be a ward of the state. I mean, that provides some more complication. But in the end, if it's a parent that's in jail, of course they're not going to be able to be present. And if they are implicated in some way, then the state's going to should be able to step in, DCFS, to protect the child's rights. So this gets really complicated, that what you just brought up.
We're happy with if it's the pleasure of the committee to pull the bill and get together and make that amendment.
Thank you.
Thank you, Senator Leding.